When do you have enough evidence to take your ex or your co-parent back to court? Hi, my name is Carl Birkhead. I'm an attorney with Worth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for almost 8 years now, and I want to help you make law easy by just talking a little bit about when and how you can expect to be ready to go back to court. So, I have this come up a lot where I have clients come to me and say that they're not happy with the current custody situation. They don't like the visitation schedule. They don't like how much time that they have or don't have with their kids. They don't like what the other side is doing during their time. For whatever reason, it's not working out for them. They're not happy with it. So they want to know when and how can they go back to court. So the first thing you need to know is if you're trying to modify custody, you have to show that there's been a material and substantial change in circumstances that's adversely affecting the health and well-being of the child and which necessitates a modification. The reason why I point this out is because a lot of times people will come to me and say, yeah, I wasn't in a great place then. I'm in a much better place now. I want to take custody. Unfortunately, that's not how it works. There's actually case law out there that specifically says just because the non-custodial parent improved their circumstances, that alone is not enough to change it. But let's say the other side is not following the court's order. Let's say visitation is being withheld or missed or skipped for whatever reason. Let's say that they're not doing anything terrible, and it's not just like one big thing, but they're just doing a bunch of little things. Keep track of any and every time that you feel like the other side is interfering with your relationship with your child or violating the court's order. And I'm not talking about big egregious violations. It can be small. You got to understand, just because we never know what the final straw is going to be that breaks the camel's back doesn't mean that you shouldn't at least keep track of the straws that are getting put on there in the first place. So visitations are being late, phone calls are being interrupted or interfered with. Uh, you know, you find out or you have reason to believe that they're talking bad about you to the child inside their home. All of these little things, they might not seem like enough on their own, but if you will just be patient and let them build up and keep track of all of them, eventually it's going to be enough. You can build a fort with a giant cinder block, or you can build it with a million pebbles. You're still going to get there. Just sometimes, and especially in these situations, it's more about pebbles than cinder blocks in these cases. So keep track of the little things. Make sure that you don't let anything slip by and document everything. And then just bring it to your attorney and say, listen, I'm just keeping track. I'm bringing this to you. You let me know when it's enough. Finally, eventually, it's going to be enough. And that's going to be when it's time to strike. If you have questions about this, or you're not sure if maybe you're at the point where you're ready to take your former partner, ex-spouse, co-parent, whatever, back to court, give me a call. My name is Carl Birkhead. I'm an attorney with Worth Law Office, and I want to help you make law easy. Thank you.